welcome back, everyone. Sorry that break got cut short a little bit, but I'm very pleased to introduce Andrew Selps, postdoctoral scholar at the Data and Society Research Institute, who will be moderating the Human Dignity, Agency, and Algorithmic Bias panel.
All right, thank you so much, and thanks everyone for being here. I just want to say a couple words. Basically, algorithms are being used in all aspects of society now, in employment, in housing, in policing, in things that probably you haven't even heard of. And they have all sorts of issues. They have issues with bias, they have issues with due process, they have issues with transparency. This has been in the news and the headlines pretty consistently for the last 3-4 years. And so you're all somewhat probably familiar with the problem. And but it's gained a new urgency, I think, actually just steamrolled urgency in the last several years. And there have been lawsuits that have been happening with Facebook, Facebook's advertising. There's a new rulemaking that the Housing and Urban Development Department is promulgating on a disparate impact rule that addresses liability when you use algorithms. There are entire academic conferences in the technical sphere, mostly technical sphere, that are actually interdisciplinary, that are trying to solve fairness. This is just a huge issue, and we have a great panel of people that come from all different disciplines, some from academia, some from practice, and you're all here to hear from them, so I'm just gonna tell you who they are really quickly and let them talk. Each panelist is gonna talk for about 10 minutes. We'll have a little bit of discussion on the panel and then open it up for questions. So going down the line, we have Anna Stoica, PhD candidate in computer science at Columbia University, Diane Hauk of counsel at Emory, Selly, Brinkerhoff, and Abadi, Rebecca Krutoff, assistant professor of law at the University of Richmond School of Law, and Charlton Mcilwain, vice provost for faculty engagement and development and professor of media and culture communication at New York University. So Anna, please lead us off.
Great, thank you, Andrew. And hi, everyone. I'm really excited to be here. As Andrew said, I am doing my PhD in computer science at Columbia, where my main focus is algorithmic bias in social networks. So I work with social media platforms in understanding how different algorithms apply to networks of people, and that has applications in the way we interact with content online, in recommendations, the people that we connect to, and in the way that information diffuses online. For example, in advertisement campaigns, in public health campaigns, in epidemics, and many others. And as Andrew mentioned, as a lot of these content moderation questions are being automated, a lot of issues appear. And this field of algorithmic bias had been increasingly receiving attention because of the fact that data encodes a lot of historical prejudices that are being picked up by algorithms and sometimes being amplified. So I come from a technical background, and I'm really interested in hearing your questions and thoughts on this space between technology and law. I'm going to talk a little bit about what is algorithmic bias and what we can do about it. So when I think about algorithmic bias, I think of this quote from Thomas McCraw that defines what is the history in general, and more specifically, history of regulation. And he says it's a rich combination of human action and impersonal circumstance. And I think that applies greatly to what algorithmic bias is as well. It's on one hand the human action at the level of designer who makes the algorithms and the biases that people bring in formulating the questions that design these algorithms. What are the purposes of these algorithms to begin with? What is the data that goes into these algorithms? Sometimes this data is being sampled in a very biased way. If we think, for example, at the stop and frisk case in New York, the data that we get in that case is the data that comes from the people that are being questioned by police. And if police are biased, then that is all the data we get. So that is one issue. But even if we remove the human aspect from this decision-making process, even if we can get all the data in the world, and as Brian mentioned earlier, we're dealing with really at-scale technologies in content moderation in YouTube. The data that Google has and is using is absolutely massive. And still, there are issues of bias there because this data also encodes the historical inequalities that exist between different communities of people. So, on the one hand, we know it's illegal to discriminate on the basis of gender, of race, of sexual orientation, of age, and so on. But these features sometimes don't come in direct form. They come as proxies in the data itself. They can be reconstructed through the zip code of where you live, through the income that you have, through the connections that you make online, and through the likes, comments, the way you interact with people online, the language and the words that you use. And these proxies can then be used not against you, but can be used to disadvantage you even more if you are in a disadvantaged position. So the other part of it is that these algorithms, a lot of them don't have a discriminatory intent. They are neutral in what they want to do. Their purpose is to rank people, to classify people, to choose between people. So even if they don't have an intent to discriminate against people, they have this impersonal nature. But yet they still encode a lot of bias. So some of the examples of how wrong can this go, as I'm sure a lot of us are aware of, come from the classic example of predictive policing with a COMPAS data set in which a machine learning algorithm was being used to predict the recidivism rates of inmates in the US. And it turned out it predicted a much higher rate for inmates who were African American, amplifying the existing inequality that exists between African Americans and whites in the US. In the more recent cases that we're going to talk about more now on Facebook advertisement, in the way Facebook that let advertisement platforms to exclude women and elder people from housing and job opportunities. And it has, of course, great applications in content moderation as well, because we can't really opt out of being online, of having an online persona. And these algorithms that may amplify bias may deprive people from having a voice and from having the same opportunity as everyone else. So to address this problem, there have been many definitions proposed to understand what is bias, and on the other hand, what does it mean for an algorithm to be fair? So there is a great body of literature that mainly from computer science that I know of, I'm sure from other fields as well, that is trying to define what is fairness. And to give a sense of what is the technical difficulty at this point is, well, firstly, this problem is not technically solved. We have many, many definitions of fairness. They're all valid, and most of them rely on two main principles, one of them being an extension of the 80% rule that turn into this notion of statistical parity. You want that the demographics that go into an algorithm, say 30% of people who apply for a job are women, to be reflected in the output as well. So you want, out of the people who receive a job, 30% of them to be women. So you want, in a sense, there's this notion that an algorithm should mirror, at worst, the data that gets fed into it. The other notion of it relies on this Rawlsian notion of equality of opportunity, that similar people should be treated in a similar way. And although these are very sound notions, it's not easy to apply them in every single context. It's not easy to find an overarching definition for what does it mean generally to be fair. And I don't think we should find that. I think this is a very context-dependent situation when we should look at a case-by-case basis and decide what is fair there and what is not. Maybe for me, getting a similar ads for clothing doesn't really matter that much, but getting a similar ads for a job opportunity as my colleague who's been doing a very similar thing as me matters a little bit more. So when we're thinking about these problems, I also want to give a sense of what are the main directions or thoughts in how to solve this. And one of the main things has been the idea of whether algorithms should or should not use these sensitive attributes to make decisions, whether they should or should not use our gender, our race, our income to make decisions for us. And the initial thought of this was that no, they shouldn't use that because they can discriminate against us based on these features. And what was found afterwards is that if they don't use the direct features, they're going to use the proxies that I have mentioned before. They're going to find correlations between your income, between your location in a data set, between many other different things. So it's better to use these sensitive features to begin with in order to correct for the bias that exists. What can people do about this is, well, one thing I think we definitely need more transparency and accountability for designers. So at the very decision-making level of how an algorithm looks like, what goes in it, and who decides what is fair or not. And they have to be put in a social context. So one thing that I think it's important is to identify what is the purpose of the algorithms that are being used. As I said before, there's been this idea that algorithms should mirror the data that is being fed into them. There's also algorithms that amplify the inequalities that are pre-existing in the data set. So what should we do in that case? Should we make sure that algorithms don't amplify something that exists, or should they intervene to make things better, to remove some of that bias? It's not clear, and I think, again, it's a very context-dependent question. But that leads me to the point that we need different kinds of assessment tools for all these different contexts. And that relates to how do we assess them in terms of their purpose? Are these algorithms being used to assist with a human decision or to replace a human decision? And again, for many different contexts, from content moderation to recommendation to search engines, you have different kinds of answers. Finally, I want to make a point about how we assess the impact of an algorithm. And I mentioned before that algorithms, a lot of them are neutral in the way that they make decisions. They don't necessarily want to discriminate. But what they are not neutral about is the way they influence our behavior. So even algorithms that try to provide recommendations or to not just to different search engines or search content, they are not neutral they in the end, their purpose is to nudge behavior one way or another. And people respond to that. And one example of how people respond to that is if you remember the red feed, blue feed case on a Facebook analysis, right? On how people who are Democrat and Republican just lie in their own echo chamber and they don't really talk to each other. And this was an analysis that's done on Facebook and seeing how separated and polarized people really are. And then researchers came and said, well, okay, if they're so separated, then maybe we should recommend content for them to interact with each other. Maybe we should recommend opposite content to break this echo chamber and make them less separated. But that backfired a lot because then people reacted to those recommendations and they became even more polarized as before. So I think the takeaway from that is that it's not only that we need to make sure that algorithms are not biased, we need to take into consideration the behavioral impacts that our algorithmic designs have on people, how people respond to our decisions, and we need to monitor that in a long-term way to make sure we don't amplify the biases that already exist. Finally, one more point. Finally, for content moderation, I think algorithms have the power and the responsibility to protect voices from being stolen, as we saw before, but they also have that power and that responsibility to not exclude voices inadvertently. So I think these notions of fairness and equity has to come as a very central feature in automated content moderation. It has to be part of the design and not a constraint that comes afterwards. So I think we need to all work together from bringing notions from what we've done in computer science, but really learn from what is possible to do in legislation, in policy making, and from people who have worked on this issue at a philosophical and sociological level. So thank you. I'm going to pass the mic.
Good morning, everybody. I've been asked to join you today to talk about a piece of the Facebook litigation. I've been representing the National Fair Housing Alliance, which has challenged Facebook's ad platform in how landlords and brokers and bankers and other in the real estate industry are able to target their advertising. And I'm going to focus this morning on a couple of ways in which algorithms are used by Facebook and how some of those were challenged in the lawsuit and have been resolved by settlement, and how others are still challenges for us to think about and for Facebook to hopefully improve in the advertising platform that it offers in the real estate world. So the National Fair Housing Alliance learned, as many people around the country learned in a series of ProPublica articles, that Facebook had designed an algorithm to estimate the racial affinity of all of its users. It did not say that it was estimating anyone's race. It did not say that that was a user's race. It used a terminology that it came up with called racial affinity. And that was by creating an algorithm that looked at how each user used their page, their likes, who they interacted with, and then estimated what their race was. Once they had that in place, they then used that in the ad platform to provide it as a targeting option to advertisers. And again, I'm going to focus this morning on real estate advertising, which is regulated through federal civil rights laws, and namely the Federal Fair Housing Act. So in the real estate context, it meant that a broker could design an ad, and I'll stay here in New York, where brokers market and help to rent apartments, which is not true in other parts of the country, as it is here. So a broker could develop an ad for an apartment and then would be given the options by Facebook on the ad platform to include or exclude African American, Hispanic American, and Asian Americans. The baseline that Facebook used is that whiteness was always to be included. So no advertiser was allowed to exclude white racial affinity, only African American, Hispanic, and Asian. And I use this story as a starting point because it really reflects the role of human beings in designing algorithms and designing platforms, and how those algorithms will be used to interface with the marketplace, which can interfere with individuals' federally protected civil rights. So here, because someone made the decision not to start with whiteness as a baseline and build from that to target, which after racial affinities, then they targeted based on users' disclosed gender, they based on users' disclosed birth date. So these were actual demographic pieces of information that the user used when setting up their account in order to include or to exclude. The algorithm went farther as they layered the different algorithms onto this. The next level of algorithmic usage on the Facebook platform is one that really borrowed more from the proxies that Anna just talked about. So what it did is it then created phrases. Are you interested in excluding or including someone who is interested in a handicapped parking spot? Are you interested in excluding or including someone who reads the Bible? Are you interested in including or excluding women with children under the age of 5? And as these concepts grew, they also then layered on interests. So not just the sort of what they were guessing the status of the user was, but then the user's interests. Are you interested in including or excluding people who like country music, who rock climb, who belong to a gym, who subscribe to parenting magazines? And all of these proxies layered and layered and layered until this broker could just target and target away, and finally, at the very end of all of it, could then restrict the physical space of the users who would see the ad. And that could be done by zip code. And many studies have been done by demographers that show in the United States, zip codes are highly racially identifiable. And so on top of all those other layers of algorithmic formulas, they just created an absolute, based on address, they would convert it to zip code, and then you could restrict. So the first step of the litigation was to remove all of that first layer of targeting. Facebook removed and disabled the racial affinity immediately. There were hearings in Congress, there were a series of lawsuits filed, there was a lot of public pressure, and so they did disable that immediately. But it took several years of litigation to reach a settlement to try to remove all those other layers related to gender and age and children and disability and religion. And that's sort of the first point and first layer of changes that Facebook has rolled out as recently as just a couple of weeks ago. So as a result of the settlement that we entered into with Facebook, they have now created a way so that when advertisers come on, they're asked voluntarily whether they're placing an ad for housing or for employment or credit. If they voluntarily say they are, they're shot off to a different platform. That platform has a set of restricted targeting. It's severely restricted targeting. If the person tries to get around the question and says, oh no, I'm selling shoes, but they go into the general platform where you still can sell shoes based on gender and age and all these various proxies, there is an algorithm used to help identify whether it's housing, employment, and credit, and that will shoot it over to the new platform. There are also a number of human beings who will be spot checking. So it's a combination of using an algorithm and human review to decide what gets pushed over to the new ad platform. How that's working, it's too early to say. It really just rolled out publicly in the last couple of weeks, and so that's something that the National Fair Housing Alliance will be reviewing and testing and monitoring over the next several years of the settlement agreement. The second piece is in the settlement agreement is the first step really in this process of looking at the algorithms that are used by platforms to deliver the ads. So remember, the first step I've just told you about is the targeting on the input stage. How are different algorithms used at that targeting, that first step? But even once the advertiser targets, let's say the broker says, I want everyone, and using the new targeting, they can do a 15-mile radius from the building. I want everyone in, as opposed to zip codes, and 15 miles circumference. So it's a large area. And based on the work we had some folks at MIT do, that is sort of the minimum layer which in most metropolitan areas will keep it from defaulting into racially identifiable areas. It will reach enough of a range to overcome that segregation. So you use the new tools. The question then is, they have something called custom audiences. And one of the custom audiences Facebook developed was something called a lookalike audience. Now, in the civil rights context, in the context of housing discrimination, anything called a lookalike audience raises a lot of red flags. So they picked a bad name for it to start off with. But one of the things we found out as we dug into the criteria in the algorithm for the lookalike audience is you could group users, you could upload your client base, and Facebook would match them with users, and then the algorithm would evaluate, well, what are our current users like that is like your current client base, so you can replicate your client base. Well, they ran ads. My favorite one was 2 white men in their 20s with the same haircut, wearing very similar clothes, sitting at the same table at a coffee shop, both with coffee in their hands, leaning in and talking to each other. And it was an ad to say, if one customer on the right is your current customer, you want more like him, we'll get the customer on the left for you. And the lookalike ad campaign was racially and gender-based. They pulled that very immediately once we brought it to their attention. It hasn't run again. They've now removed the lookalike audience function. They still have a custom audience function, and that function still is based on how a user interfaces and interacts with their news feed and their homepage, their clicks, their likes. But again, we've removed out of it gender and age and zip code. They actually had religious identity. They had some terminology related to education. I was trying to see if I could find the quick list here. So that what it did is it duplicated everything in the targeting. So even if the broker didn't use the targeting, if they uploaded their current customer base and used the lookalike function, without telling you, would use the same criteria which on its face is illegal in the United States: age, gender, religious views, school, political views, zip code, location. So all of that's been removed so that it has hopefully reduced the restrictions that are in the customized audience tool as it can be used for housing and employment. What the lawsuits did not accomplish, though, is how the third and final layer of algorithms are used, which is once you place go on your ad, on the ad platform for Facebook, how is it delivered? And there have been a number of studies done and reports out there that one of the ways the Facebook ad is delivered is that whoever clicks on it, opens up the ad, interacts with the ad, the algorithm is set up to replicate more people like that. So this concept of a lookalike audience is still embedded in there. And so currently, the United States Department of Housing and Urban Development has charged Facebook with discrimination. Its charge includes addressing this third type of algorithm. That is in direct conflict with the disparate impact rule that HUD has now proposed. So right now, the case is with the U.S. Attorney's Office, but they have not filed it in court, and they have not made any public statements on whether the federal government will actually be moving to enforce and try to address this third layer.
So, hi. So I just have to jump in here sideways. I worked on fair housing for 4 years, and housing is so critical to schools and to employment opportunities and all of the mechanisms that we think of for social advancement and learning. So yeah, this is just in the greater context, housing is so critical. Those three always interplay. Anyways, hi, thanks so much to the Fordham IP Media and Entertainment Law Journal for the opportunity to be here and for organizing this fantastic event. My research generally focuses on the interplay between law and new technologies, how both of them can influence the evolution of the other. Today, I'm going to talk specifically about how artificial intelligence is increasingly being integrated into our common law judicial process and why this risks, for reasons they have explained, also incorporating bias and scaling it at a level that's not seen when individual human judges are biased. Most of what I say is going to be focused on judges in the common law process, but a lot of it can be equally applied to content moderation. So just wanted to put that out at the outset. Okay, so AI is already incorporated into our judicial system in a variety of ways. It helps litigants in various ways. Do Not Pay is an AI-based chatbot originally designed to help people get out of parking tickets. In a couple of years, it eliminated about $9 million worth of parking tickets, and they've now expanded the algorithm so it offers a panoply of legal services, including helping individuals request maternity leave, seek compensation for transit delays, and report suspected discrimination. Companies rely on automated chatbots to help resolve customer complaints and address them. Cities employ systems to automatically generate citations for minor traffic violations. And right now, an Estonian team is designing a robot judge to adjudicate contract disputes for small amounts. And they're really excited about this and its potential to reduce case backlog. And Estonia has traditionally, it's a very wired country, has sort of traditionally led the way in terms of new innovations in the tech sphere that are incorporated into other countries' systems. So first, I'm going to spend a little bit of a time explaining why I think AI, at least standing alone, is a bad judge, and then talk a little bit more about why pairing a human with an AI system, creating a sort of cyborg judge, is also a bad idea. At the same time, it's probably happening more and more, and so we've got to think really intentionally about how these systems are going to be designed. All right, so if AI can help us with filing our taxes, certainly, I use an AI system to help me with filing my taxes and filing legal complaints. Why can't it decide disputes? Certainly, there is much to critique about the justice handed down by human judges, right? They're famously inconsistent as a group, right, across different judges. They're also inconsistent as individuals, right? The same judge at different times in his or her life or at different times in the day might render different kinds of decisions. And that undermines the fairness and predictability of the legal system. And of course, there are human beings with human prejudice. Finally, they're inherently expensive and limited resource. It takes a lot of time and money to make a judge who only then is a judge for a limited period of time for a limited number of cases before they retire. So unlike arbitrary, expensive, temporally and spatially limited human beings, algorithms promise the possibility of cheap and fast, consistent, and apparently impartial results that can be scaled. So they suggest the possibility of cheap access to justice for all. That's really attractive, right? That sounds good. But these these promises that their advocates are making are often based on assumptions about how machine decision-making operates that come in some ways from our tendency to anthropomorphize these systems, right? To say, well, we are so familiar with human decision-making processes that we put it on the algorithms. But actually, today's AI tends to produce results by detecting patterns in data, these look-alike would be an example, and using rules to translate those patterns into information that can be processed by computers. They excel in very limited, narrow settings where the rules are well-defined, where there are clear right and wrong answers, and where speed creates an advantage over human decision-making. So really great at chess, really bad at judging, right? This does not describe the kinds of the way that we want, the kind of judgment we want. We don't want speedy, very rule-based judging. The judging we value in a common law process is sensitive to context, to extenuating circumstances, is flexible, is able to evolve in light of evolving social norms and social practices, and new technologies. That is exactly the kind of decision-making that AI is terrible at doing. It is consistent, but it is brittle. It is inflexible. And maybe that will change in the future, but until it does, we need to be very cautious about when and how we incorporate AI into judicial decision-making. It's also worth noting that it's not easy to translate laws in statutes and common law into easily applied algorithmic rules. My other side job is I do a lot in law of war and autonomous weapon systems. People are like, can't we just codify the rules of war into autonomous weapon systems? Like, no, even really simple laws are far from unambiguous. So for example, a study tasked 3 groups of programmers with automating New York traffic rules, speeding rules, okay? That seems like a relatively clear and simple kind of rule, right? But consider the choices you would have to make in trying to figure out when to issue a ticket. Would you issue a ticket for every single infraction? Would you issue a ticket if the driver went 4 miles over the speed limit, 8 miles over the speed limit, 12 miles over the speed limit? Norms change depending on where you are and how much over the speed limit people feel entitled to go. Would it matter what other drivers are doing at the same time, or would you evaluate every single car individually? So unsurprisingly, these different groups of programmers, one was tasked with programming the letter of the law, one was tasked with programming the intent of the law, and their results differed immensely, particularly in issues like whether their software ticketed minor infractions, the extent to which a cluster of violations was considered one or multiple violations, right? So if you go 4 miles over the speed limit, you drop down to the speed limit, and then you go 4 miles over again 2 seconds later, and then you drop down, whether or not that was considered a cluster or not, and also whether or not there was a minimum inter-ticket time. So as a result, for the exact same factual scenario, the letter of the law programmers would issue 498 tickets on average, while the intent of the law group issued 1.5 tickets. The exact same factual scenario. So the authors concluded that even relatively narrow and straightforward rules can be troublingly indiscriminate in practice. Clearly, judging requires more than rotely applying facts to rotely applying unambiguous rules to facts. Finally, I'll go over this quickly because Anna did such a great job on it. Despite its veneer of objectivity, incorporating AI will not solve the problem of human bias. AI systems can be biased due to bias in the training sets, particularly in law, which is a domain where we just don't have a lot of data except for few very small specific niches, and the data in those niches are very biased. Biased in the system design itself, As I noted, the same rule can be programmed any number of ways, and these differences breed disparate and discriminatory impacts. And bias that emerges from technical limitations, just the simple act of trying to translate reality into facts that are computers can digest and employ, introduces error. Okay. Finally, when compared with the biased decisions of human decision makers are at least relatively contained to individuals, and we do have a justice system that has a lot of faults, but still does have a system for curbing the worst excesses of bad actor judges. AI judges, they're attractive because they can be scaled, right? That's part of the appeal, is that you can use the same program across a lot of jurisdictions, but with scaling will come scaling all of these biases and errors in a consistent way. With human judges, there's also a possibility of detecting bias. An individual human judge has a longer history than just one decision, and you get to look at that. For AI systems, it might be really difficult to detect their errors when they happen. So depending on the structure of the algorithm, it might not be possible to plumb the reasoning to understand how the error occurred at all. And in addition to technical barriers to transparency, trade secret laws, and other legal shields allow the companies who develop these algorithms to not allow anyone to access the information that would help you determine through testing whether or not it's fundamentally biased. Now, you can get around that sometimes with lawsuits, but this is where trade secret law operates as a bit of a shield. So in short, human beings, machine systems process information and reach conclusions in fundamentally different ways, with AI being particularly ill-suited for the kinds of rule application and value balancing required in judging. So, okay, why not cyborg justice? Why not try and take the best of both worlds, minimize the problems of both, and get everything that we like about both of these together? Certainly, Centaur chess teams where you pair AI with humans do far better than either kind, humans or AI acting alone. But teaming raises a bunch of new issues, including overtrust and skill fade for the human in the loop, right? They trust too much, and so they're not exercising the human reasoning that we're looking for. Undertrust risks overinvestment in useless and annoying infrastructure that will only be used to critique judges when people disagree with their decisions. And the design interface itself creates an additional source of bias and error because it's hard to translate information in a way between humans and machine systems. So we now have a bounded opportunity to design some cyborg justice systems that try to take the best of both worlds, but it is a much harder task than I think a lot of the advocates of it seem to be willing to acknowledge. We need to be aware of these potential sources of bias when doing so. Thank you so much.
Thank you all for being here. My name is Charlton Mcilwain. I'm going to resist, I think, probably what we're all doing, which is responding directly to each other's comments, at least at the moment, because there's so much interesting and to understand and overlap. And so I prepared comments knowing my tendency to veer off track to do just that. So what I want to do today with the time that I have is to do something a little bit experimental. I'll start with just giving you a little bit of background and context for my remarks so you know a little bit about where I'm coming from. My work over the last few years has been focused on trying to understand how algorithmic systems, and this has typically been focused on search engines, internet traffic systems, how they model offline structures that present or systemically produce racial discrimination. The second thing I've been spending most of my time with over the last few years is writing a new book that's called Black Software, the Internet and Racial Justice from the Afronet to Black Lives Matter. And then finally, spend an inordinate amount of time over the past few years on a case that never seems to go away, working as an expert witness in a reverse redlining, racial targeting in predatory lending case called St. John versus Immigrant Mortgage Company that was litigated by civil rights firm Relman, Dane, and Colfax in DC. So all of these things kind of shape my kind of where I approach this set of questions about algorithmic bias. And so what I want to do is to start by contending that there is a common root, a tie that binds, a connecting thread that links together today's algorithmic systems, whether we're talking about risk scoring algorithms, advertising targeting algorithms, online reputation algorithms, resume screening algorithms, facial recognition algorithms, recommendation systems, we could go on and on. I want to contend that they are all animated by a common spirit and powered by a shared ambition, and that is the need, the impulse, the drive, the promise that they can solve an urgent, significant, and sizable problem. So in this opening, I want to make one simple point, and I want to try to do that by identifying this persistent link between what I call the racial logics that drive discrimination and inequality on the one hand, and the algorithmic and coding logics that power computers on the other. And I want to frame this point as a brief conversation between three people, maybe four, depending on how I do on time. Those four people: President Lyndon Johnson, Tom Watson Jr., heir and former president of IBM, sociologist and civil rights activist W.B. Du Bois, and Roy Wilkins, one-time head of the NAACP. And so what I want to do, as you can guess, is to basically come at this sort of zooming out and zooming back and giving a little bit of historical context for the lens in which we try to understand present-day issues around algorithmic decision-making, algorithmic bias, and the ways that they impact and disparately impact particular communities. So beginning that conversation, President Lyndon Johnson, March 1965, who said these words in a longer speech: "But rarely in any time does an issue lay bare the secret heart of America itself. Rarely we are met with a challenge not to our growth or abundance, our welfare, or our security, but rather to their values and the purposes and the meanings of our beloved nation. The issue of equal rights for American Negroes is such an issue. There is no Negro problem. There is no Southern problem. There is no Northern problem. There is only an American problem. And we are met here tonight as Americans, not as Democrats or Republicans. We are met here as Americans to solve that problem." Tom Watson Jr., president of IBM, December 1965, had this to say about his own company, IBM. "The company's mission is to solve problems as they may exist in business, science, defense, education, medicine, space exploration, and other areas." Really what he meant was pretty much every area of human life. "To perform this mission, the company conducts basic and applied research, development, and manufacturing, engineering, marketing, and maintenance operations." These two parts of the conversation are interesting largely because of what came in between. Does anyone want to venture a guess? All right. It was the Watts riots in August of that year. So one of these remarks, Lyndon Johnson's, comes 4 months or so before, the other about 4 or 5 after. And these are linked in very specific ways that I won't go into now. W.B. Du Bois, which takes us even further back, 1903, his famous book, The Souls of Black Folk. And I'll curtail some of the context here and simply go to the quote that many of us are familiar with, where he says, "To the real question, how does it feel to be a problem, I answer seldom a word. And yet being a problem is a strange experience, peculiar even for one who has never been anything else." How am I doing on time? I'll just keep going. So you tell me. So I'm going to bring in then Roy Wilkins to sort of wrap up this conversation and then move to some concluding remarks. These, this statement from Roy Wilkins comes from an interesting op-ed that he wrote in the Los Angeles Times, 1967, also following many strings of race riots that were happening consistently across the 60s. The title of the op-ed he wrote as "Computerize the Race Problem?" And so I'll skip most of it and go right to the end where he says, "When I look now into the skeptical eyes of bewildered white observers of this riotous summer, I think of the Arkansas sharecroppers, of Anthony Crawford, a Negro farmer who was lynched because he was, quote, too prosperous, of the Negro families who wore their old clothes to town in order to offer no disturbing comparisons with those of white folks. No, all Negroes have not been shiftless or without ingenuity or the will to get ahead. The hardiest have advanced despite obstacles and have fought and paid for opportunity for their children. But many scores of thousands who now should be giving the overwhelming answer to the question of Negro ability were hobbled and crushed in spirit. The psychological children of this treatment are the 1967 rioters. Near relatives are their embittered but non-riotous supporters. After the computer," and I love this question, which I have thought about for many, many hours over the last couple of years. "After the computer has defined on tape the ideal Holstein, could it then turn its impersonal, unprejudiced magic upon our agonizing race problem? Could it not, after digesting the facts which both whites and blacks have fogged over for so long, give us an outline of our obligations? Instead of being a measure of the Negro's lag, cannot the computer become a guidepost to interracial justice and peace?" And so the point, one of them I want to make, is that when we go back to Du Bois's question about how does it feel to become to be a problem, to know what it feels like to persistently be a problem, to know a life that is nothing but being a problem, is that the problem with perpetually being a problem is that you become the object of anything and everything that calls itself a solution. And so when we think about today's algorithms, automated systems, AI, many of which are solutions looking for a problem. And the question I ask is, what happens in that case when those problems are already historically identified and persist? So what I'm trying to point out here is that if the problem, or if it is the problem that links race and discrimination to algorithmic systems, then understanding who the problem is and how it or they are framed as such helps us to understand the problem of algorithmic bias, or what I simply call racism. It is why I love Sophia Noble's framing, which in her book she titles Algorithms of Oppression, or Ruha Benjamin's description of it as the new Jim Code. Further, if we were to understand why the problem of algorithmic discrimination persists, excuse me, then we should look to whom in the public imagination persists as problems: Black people, brown people, people of color, immigrants, migrants, refugees, homeless, welfare cheats, the formerly incarcerated, the poor, the panhandler, the homeless, the jobless, and the list go on, and they share a common theme. These are the folks that Airbnb folks don't want in their homes. They are the folks that the real estate advertisers use Facebook's ad targeting algorithms to steer away from their neighborhoods. These are the folks who face ICE and the NYPD, who faces ICE and NYPD want to track, and employers who want to screen out from their jobs. And so I argue in closing that if we are to somehow fix, address, or even attempt to try to frame the problem we call algorithmic bias, then we must deal with the cause and effect, which is to say, we should not be led astray that revealing the algorithm, auditing the algorithm, tweaking the algorithm, debiasing the algorithm is a viable solution. They are good, but not the only viable solution. It means that our solutions must primarily be focused on shifting our imagination to be able to describe, define, and frame our problems differently, to define and collect the data that powers our algorithms differently. And I'll stop there.
Thanks so much to everyone on this panel. Those were all fascinating remarks. No, oh. Hello, is that better? Sorry, just saying, thanks. Those were all like really fascinating remarks. I've got a couple questions that maybe can spur some discussion, and then after about 10 minutes or 7 minutes, we'll go to the audience for questions as well. So the first question I want to ask is for Diane, actually. When we hear about algorithmic discrimination, it's usually about some opaque black box that's totally inscrutable. But it seems like what Facebook was doing was a lot more blatant. Was just presenting discrimination if anybody happened to mention, hey, advertisers get this option. It sort of reminds me of the difference historically between segregation or discrimination in the Jim Crow era and what discrimination looks like today, which is a lot more underground. I'm wondering if Facebook were to fix this problem, whether it just moves more underground, or if there are things that platforms can do to more proactively combat discrimination in a meaningful way rather than just hiding it.
Well, that's the challenge of the settlement agreement, and why I gave the 3 examples I did. The most sort of obvious on its face that even reporting about racial affinity, everybody, even Facebook, knew to stop that. Then the middle layer, which was really looking at things like zip codes and lookalike audiences and interests, which the lawsuit was able to address and remove from the system. But the third layer is the tough and challenging layer, and that is what algorithm is used in the delivery of the ads. Is Facebook actually delivering the ads according to the advertiser's wishes? We don't think so. There have been some studies done that suggest that, particularly in the employment area, where you can and have been able to search based on gender and age. There have been some studies show that, for instance, if you put an ad out for a particular job, and within the first 24 hours, primarily women under 40 have clicked on that ad, then the delivery system will change the next day to deliver it to more women under 40, even though the advertiser did not click off gender or age. So I'm guessing that's happening somehow in housing as well, but there's no way to study that or know that. The HUD charge begins to address that problem. If the federal government were aggressive in its enforcement efforts, I think that would be a way to begin to address it in a manner that private litigants, civil rights organizations, and individuals don't have the tools. But that is our challenge.
Thanks. So to that, I actually want to ask you a question to Anna. What we're hearing here is that if you actually start to try to police discrimination, it's going to get harder and harder to detect as a technical matter. As I understand it, in some of your research, you've done some of this, like auditing of algorithms to try to figure out where they are actually discriminating. How do you do this technically? What are the technical challenges and what abilities do we have to do the audits? Assuming we have access to the algorithms, which may be a whole different question.
Yeah, I think that's one of the biggest challenges, having access to the algorithms themselves. So a lot of my work has been in trying to, in a sense, reverse engineering what algorithms are doing, simulate them, trying to get access to data that has been used by algorithms and trying to assess what that effect is. So in a sense, I think what I've been doing so far is to try to see what kind of disparities exist in the data and what happens after an algorithm is being used on such data, right? So I've been talking about many definitions of how can we assess this disparity. Can you see what demographics have been initially in the data, what disparities exist between them, what kind of inequalities exist in the way people connect to each other, in the number of connections that they have, in things like that can be measured on a social network, and what happens, how can we track these quantities as an algorithm is being ran on a network. And what I found so far is, for example, with recommendation algorithms, is that your position in a network matters a lot, who you are connected to. That can be one important metric when you work with social networks and when you interact with your friends. That is very, again, context specific to you being in a network of people and being connected to them. And what happens is that if you're not connected to the right people, or if you are in a marginalized part of the network, you're not simply, it takes longer for you to receive information, it takes longer for you to get good recommendations. So, and these appear as, so we identify these as issues of being biased, of an algorithm being biased against you. But there are many problems that come with these definitions as well. This is a very specified, a very specific example. But a problem that we're facing is, how do we define this in other contexts? Do we have different ways of assessing this? There are many different ways of defining what is fair or what is biased from an algorithmic point of view, but we don't have a way of structurally seeing in each context what is the right thing or what is the right definition to do it. There are, as I said, a myriad of different definitions, and I think we just probably need even more than what already exists to do that. So I think one of the big challenges to try to solve here is to try to understand the social context of what we mean by bias, what does it mean to be fair in each context, and to treat each case separately. In housing, there's issues that are associated to housing and what is discrimination there. In employment, they might be different. In recommendation or content moderation, those might be different. And I think we just need very different assessment tools for each of them. So I gave an example of one, but I think we need to expand beyond these technical terms and see what is at stake at a larger scale. Yeah, thanks.
Thanks. So Charlton, I really liked your framing of talking about problems, right, and how we conceive of problems. And it's interesting because when we think about algorithmic bias issues, problem definition, the technical idea of problem definition, so often is the first example of a human decision that goes into the algorithm that ends up having results downstream. So an example I like to give a lot is if you're a bank optimizing who's going to get loans, you can either be optimizing for maximum profit or you can be optimizing to give loans to the greatest number of people who are likely to pay them back above a certain threshold. Those are two totally valid, in some sense, targets, and you'll get totally different answers, right? Problem definition matters. So taking it back to the level of society, right, how we think about what problems that ML is even generally solving, right, thinking about the fairness definitions are different problems. I wonder what you think the rhetoric of neutrality does to our conception of problems, of race and issues, like what the technical, like what this thing that we're all fighting against rhetorically, how is that shaping how we think of the problems in society?
Yeah, it's a good question. What I usually find myself fighting against is the sort of definitions of fairness or neutrality or colorblindness or things of that nature, because what historically we know typically happens is things get diluted, right? So it's not a question of fairness, but a question of racism in terms of how I frame it. And you miss the race-specific angle if what your driving concept is or frame is about fairness. It also means that when we talk about fairness, we are, in my opinion, drawing some false equivalencies in questions about race, et cetera, historically, looking at inequality, looking at ways of intervening to balance the scales that we miss when we simply frame this as being fair. So can I leave that answer there and just say a quick thing about the question you gave to a couple of others that I think was very important. Facebook, when we look at their targeting and that case, it's great because of its sort of explicitness, right? And even if there was not the intent to discriminate, you could see that they, basically used a very long historical way of having other folks or facilitating other folks being able to discriminate. The tougher question, as folks have mentioned, is we don't limit our online traffic and so forth to a platform, typically, right? We move across the web where ads and so forth are a part of the ecosystem and environment that are likely targeting in many of the ways that we see very specifically on a single platform, but we don't have the kind of empirical way to test that and to test the ways that discrimination are happening inadvertently, consciously, and explicitly. So yeah, I'll do that. I'll stop there. But
Yeah, I mean, the detection
it's-
is just so hard.
Right.
Like so much of the work in this, in the technical work on fairness, is sort of from this theoretical examples of toy problems and how to mathematically solve these things. And yet, there's all this stuff going on that's either protected by trade secrets or standard corporate secrecy that isn't in law, and or just infeasibility of testing that makes it all
yeah,
go by.
scale is outrageous.
So I just conscious of time, I want to make sure the audience gets a chance to ask questions. So please raise your hand if you have a question, and someone with a mic will come around.
Hi. Let me start by saying I'm not defending Facebook. I have enough issues on my own. But I'm curious. Imagine it's 1990. Not a lot of people are on the internet. Look at magazine advertising, right? I'm going to advertise men's watches in GQ. I'm going to advertise diapers in parenting magazines. And brands are going to do that in large part because they think they know something about the demographics, right, of that readership. Today, when we look at online targeting, is it a change in degree only, or do you think there's a fundamental change in kind, right, of targeting that's going on that makes it more problematic? And I guess additionally, what's the right thing, right, for Facebook to do here? Brands want to do this, right? So how is it avoid any protected characteristics or their near proxies? Is it, what's the right balance for them to give advertisers some of the targeting techniques they want without running afoul of discrimination?
Well, I'm going to respond to the first question primarily because I think that is a very interesting and important question. In 1968, we adopted the Fair Housing Act nationally in this country. And in that law, specific provisions were contained regarding advertising to hold responsible and prohibit not just the advertiser, but the entity that published and made public the illegal statements and the advertising. So as far back as 1968, Congress understood that within housing markets, there were two steps to the process. Whether it was a newspaper or a magazine, or 50 years later, the internet, there are two steps to communicating ads in real estate that law was specifically intended to prohibit. And all of the exceptions in the law, the Mrs. Murphy exception, little old lady lives upstairs, she rents out her apartment downstairs, the fair housing law doesn't cover that, she can pick who she wants to as long as she doesn't say anything bad. But when it comes to advertising, the law has always been no exceptions. That's how serious Congress took it. With the passage of the Communications Decency Act and the provisions in there, which was Facebook's primary legal defense to this lawsuit, remember, Facebook publicly says we support civil rights, we are against discrimination, but in court they say we are exempt from the nation's civil rights laws because of the Communications and Decency Act. So we have a fundamental conflict in our laws right now, and that's one of the things I think we need to address, perhaps some changes to the Communications and Decency Act to clarify and bring it into sync with the fundamental principles of our civil rights laws. The second question, I'm probably not the best person to address, just from a technical standpoint. I accept to say that I think the settlements are really only the first step in both the enforcement of the laws and curbing of the worst of abuses, because this really is a new generation of what advertisers did in newspapers and magazines in the 1960s. And that with this sort of new generation and initial curbing, we have to think creatively of how we are going to audit and test and detect and enforce, and what would be the role of regulatory agencies, the Consumer Financial Protection Bureau, the Department of Justice, and HUD, using the authority that they have under federal civil rights laws, which is much broader than individuals and organizations have, but requires the public will to enforce them. And I think once those steps begin to be taken, then companies will need to sit down and reevaluate. One of the first backlashes to the Facebook settlement is there are a number of other platforms around the country. Go on YouTube. You'll find them easily. Now that Facebook has been curbed, come to our site, buy our services. We have a different way to help you target your office. How do you fish? And fishing, for anyone involved in real estate, finding new listings. There are videos out there on how to fish and get around the restrictions in the Facebook settlement. So Facebook is just one piece and the first example of this. It's a broader systemic problem.
I just wanted to quickly say, this is implicit in your answer, but it bears being explicit about it. There is a fundamental difference between watches and housing in terms of the opportunities that are provided by the latter. And so there's a reason to have stricter rules for advertising in housing than in watches.
And if I could add to your second question about what to do or what should be the obligation, I think at least in part the obligation should be to scrutinize the services in much the same way that Andrew articulated earlier. So if I'm a bank, am I optimizing for opportunity or am I optimizing to mitigate risk? The latter tends to point us in the direction of exclusion and problems, the other much more inclusive and broad. So I think at the very least, platforms have the obligation in this new advertising kind of systems to monitor and know what their partners and advertisers are doing in that respect.
The mic for Hannah.
Hello. I wonder if Provost McIlwain and pardon me, maybe another speaker would address the why of this problem. And I deeply appreciate your comment that tech companies talk about algorithmic bias when what we really should be talking about is a racism inherent to it. Do you think that the why of what's going on today results from a lack of an ethical grounding, a lack of what's the term, epigenetic recollection of the 1960s and 70s? I mean, it is 51 years since the Fair Housing Act was enacted, not merely adopted, but enacted into law by the United States Congress. Why has this generation, and I hope nobody is offended if I use the term millennials, who are largely the engineers and the decision makers at the technology companies, not aware that it's necessary or appropriate to simply say, hey, this isn't right? Is it that they're not consulting in-house counsel, or that they perhaps lack that ethical founding? And should that be taught in the engineering schools, for example?
Yes, it should be taught in engineering schools. But I'm pretty generous, having spent a lot of years talking to designers and engineers and so forth. And when I bring up this question about, are algorithms biased, or racist, et cetera, who literally look at me with a look that says, I have no idea what the hell you're talking about. No conceptualization of what you even mean. And I think that's in large part due to this kind of lack of memory, historic sensibility, in which they are raised and taught or are not taught. And so I think the issue is really a lack of facility with that kind of context, and a myopia that is really just targeted on what's the problem, how do I solve it, what's the technology in which I can produce the solution. And so it's interesting always to go into a technical context and talk about things that are fairly basic in terms of history of race, discrimination, inequality, and have a room full of people, and the age ranges fairly decently, that just simply don't have any connection or context.
If I could actually just jump in on that, I totally agree with all of that. I think there's something built into the sort of disciplinary training of engineering The first concept you learn in your intro computer science class is abstraction, is formal abstraction, is to put boundaries around the problem you're solving, to isolate it and not break those boundaries because then you're doing sloppy work. The thing is, that necessarily excludes a lot of the things that the messiness that we're now encountering and worried about. And so even the best intentioned, most ethical engineers start out with this training, and you have to sort of unlearn years and years of training in order to even process what it means to have biased systems in a social sense. And so it's just a really hard, thorny problem of interdisciplinarity that people with the best intentions will have a hard time with. So.
Oh, I wanted to add really quickly to that I think also, well, seeing a lot of people in the technical context of computer science or math, it's true that they miss out, we miss out on the social context of what this actually means, and that algorithmic bias is indeed more racism than bias. And I think I agree with you that a lot of engineering schools should include an ethical component to their curriculum. I've seen schools started to do that. I've seen Columbia started to include in their computer science courses an ethical part of each course. I think that's a good start, but it's probably not enough to like solve the problem. And I think I agree that we need to move away from formalizing these problems in terms of math and just placing them back where they actually belong, which is the social context of discrimination and bias.
We have time for one more very quick question.
Could I just make one comment? I don't want to dump too much on the engineers. I come from a family of engineers. I'm actually the only lawyer, and they wonder what went wrong with me. It's the decision makers we also have to think about, because engineers will tell you we code, we create, we design what the client asks us to. And after they review our initial framing and our initial design, they approve it. They decide what changes will be made to it. And they decide what the boundaries are for it. And I think, unfortunately, in this rapidly changing tech world, the developments of apps and platforms are happening so quickly that companies are skipping some of that very hard compliance and internal review work to make sure that they've really scrubbed out their products before they go out to the public.
Thanks, that's a great point. All right, Hannah.
I'll just speak loudly. I actually, well, I had two questions. One is fairly simple. Rebecca, you talked about how I think AI judging would only be targeted towards small contract disputes, and I was just wondering why those disputes only, or is there something inherently about contract that's easier to adjudicate? And the second question is, you talked about fair housing predominantly, Diane, but I'm just curious about the Title VII context. Is there something inherently biased against individuals filing suits in these kind of claims for ADEA or Title VII where they're not even aware they're being discriminated against in these kind of ads? Would it take a whistleblower to file these kind of actions? I mean, how would an employee, someone who's looking for a job, even know that they're being discriminated against in these kind of contexts?
30 seconds each.
Yeah, small claims because it's a safe place to play and experiment, and contract disputes because it's perceived as relatively clear. But if you've taken a contracts class and tried to do an issue spotter exam, then you know that's not necessarily true.
The question about Title VII in the employment context is, how does an individual employee even know they've been discriminated against? That applies also in credit and housing, and that is a very key challenge today. One of the reasons why the National Fair Housing Alliance brought the suit, and in the Title VII context, it was a union, the Communication Workers of America, who was a plaintiff challenging the employment side, is because those organizations are able to conduct investigations, collect data, test. So, you know, the National Fair Housing Alliance and its members set up fake real estate companies on Facebook. And they came up with ads of various different kinds to push all these buttons about zip code and gender and race. And they waited to see if Facebook would accept them. And Facebook never disappointed. They always did. And then the ads were withdrawn so that they wouldn't go into the public and interfere with the public searching for housing. But unless you have those tools, unless we're able to use the concepts of standing to apply to organizations, unions, and nonprofits, it is nearly impossible for anyone to know when they're being discriminated against in this way. Yeah.
All right, well, everybody, after this panel, please proceed across the hall to lunch.